today's exclusive webinar brought to you by VET Resources. We're so glad you could join us. In today's session, we have Ben Thakkar, CEO of VET Advisory Group, and Peter Doukas, Managing Director of Denison Toyer, leading us through the National VET Regulator (NVR) Act and how it impacts your RTO's compliance. Get ready for actionable insights on the following key topics: RTO transfers and acquisitions, understanding the legalities and processes involved in RTO transfers and acquisitions, demystifying the NVR Act, how the NVR Act impacts your RTO's operations, governance, and compliance obligations, real-world pitfalls, legal examples of common mistakes and how to avoid them, steps for compliance, practical steps to stay compliant and audit-ready under the 2025 standards. And remember, if you need RTO consultation, RTO registration, re-registration, addition to scope, or high-quality RTO resources, we have you covered. With the biggest catalog of RTO resources in Australia, including learning and assessment kits, RPL kits, LLND kits, PowerPoint presentations, SCORM, and e-learning files, we're here to help your RTO thrive. Request RTO consultation or request free samples now to see how we can support your RTO's growth and compliance. Welcome to today's exclusive webinar brought to you by VET Resources. We're so glad you could join us. In today's session, we have Ben Thakkar, CEO of VET Advisory Group, and Peter Doukas, Managing Director of Denison Toyer, leading us through the National VET Regulator (NVR) Act and how it impacts your RTO's compliance. Get ready for actionable insights on the following key topics: RTO transfers and acquisitions, understanding the legalities and processes involved in RTO transfers and acquisitions, demystifying the NVR Act, how the NVR Act impacts your RTO's operations, governance, and compliance obligations, real-world pitfalls, legal examples of common mistakes and how to avoid them, steps for compliance, practical steps to stay compliant and audit-ready under the 2025 standards. And remember, if you need RTO consultation, RTO registration, re-registration, addition to scope, or high-quality RTO resources, we have you covered. With the biggest catalog of RTO resources in Australia, including learning and assessment kits, RPL kits, LLND kits, PowerPoint presentations, SCORM, and e-learning files, we're here to help your RTO thrive. Request RTO consultation or request free samples now to see how we can support your RTO's growth and compliance. Welcome to today's exclusive webinar brought to you by VET Resources. We're so glad you could join us. In today's session, we have
Good morning, everyone. Hello. Good morning and welcome you all on today's webinar. And I'm Mahi. I'll be your host for today's session. Before we start, I would encourage all of you to turn on your cameras so we can see your lovely faces, and that helps us to make a connection with you. So I'll give you a few seconds. If you can, please turn on the camera, say hello to us. Thank you, whoever is turning the cameras on, and I would still give you a few more seconds. Please do so. This is like the only reason why I'm asking, like this is how we know who is our audience. We can make a good connection with you. Also, I've said many a time, I'm trying to make a community here so we can help each other. So thank you once again. Today, just so you know, it's going to be an amazing webinar because we are going to share so many information and so many valuable insights. Today, we'll be looking to how RTO can understand and prepare for legislative landscape in 2025 with the focus on National VET Regulator Act, the NVR Act. And this session is all about what NVR Act means for your RTO, what's changing, the risk of non-compliance, and practical steps to keep your organization audit ready and risk-free. And today, joining us, our two highly experienced experts in VET sector, Mr. Ben Thakkar, a CEO of VET Resources and VET Advisory Group, Ben is a compliance specialist who has supported over thousands of RTOs across Australia to improve their operations, strengthen their compliance, and stay audit ready under VET standards. And joining him, Peter Doukas, a managing director of Decentoya. He is an education lawyer with extensive experience in regulatory compliance for RTOs. He has presented many VET related conferences, including WELG, and he is well known for helping RTOs understand legal requirements and avoid potential risk. Hello, Peter, how are you? And
Very well,
hello,
thank you.
and hi, Ben, as well. How are you?
Good. How are you, Mahi?
I'm good, good,
Good
good.
morning to everyone.
And we are so excited to hear from both of you. And I know today's webinar is going to be so much informative, and people must have, everyone has a like pen and paper ready to take their notes down as well. And so once again, welcome to both of you. And before we get started, a few housekeeping reminders for all of you guys out there. Your microphone will be muted during the presentation just to run the smooth session. And also, if you have any question, note them down in the chat box. We will try to cover all your questions at the end of this session. And just because we have two speakers here, we wanted to avoid a confusion. So make sure when if your question is directed to Ben, you can add Ben's name next to your question. And if it is directed to Peter, add his name. So just avoid confusion. And we will try to make sure that we can cover all of your questions, but any of the questions that we could not get to, we will try to cover them in our upcoming videos. So keep an eye for the upcoming videos as well. And without further ado, I'm going to stop talking and I will let Ben, please Ben, go ahead and share your insights.
First of all, good morning, everyone. I'm super excited today for the session talking about NVR Act, and also super pumped that Peter is joining us today. Peter and I know for very, very long. So many things I learned from the Peter. And that's why we had a chat that with Peter experience and knowledge and skills, we're going to add a lot of values to you. That is our goal for the session. So that's why I'm super excited and pumped. NVR Act, like why we decided we discuss about acquisition and NVR Act is like, I can tell you my story that I was in the RTO sector for, let's say, 5 years and 7 years. I was getting an audit report where is always quote NVR Act section 29 to 30 and da 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 da. And I was scratching my head every time. Like it is nowhere written in the SRTOs 205 what this section in NVR Act looks like. And then started as a curiosity. Oh, maybe that is coming from the NVR Act section, which is the bigger act. And then I was starting opening about, it's pretty huge, the documents. Then I started reading a little bit about it. It's still very extensive document. So then we thought that, okay, why not we share that experience so everyone get to know what the NVR Act, what are the powers that regulator possess, and how can they utilize that power, and if something happens, what can you do? And then Peter will take into a much more in-depth about NVR Act and acquisition, or if something goes wrong to the RTO, what step needs to be taken. So without further ado, I'll share my screen. Let me know if you're able to see the screen. Give me a thumbs up, thumbs down. Is it all good?
We can see it, Ben. Yes.
Okay, great. So what we going to cover today? That's why I'm starting from the basic, and then Peter will go into the deeper level. The main agenda is that what the NVR Act actually is, what legislative ecosystem under the Act, ASQA's core enforcement power. So what are the power that regulator possess due to the NVR Act that ASQA has not fully exercised yet, some of the power, why the NVR Act matter for more in 25-26, and what RTO leader must prioritize next year. So that's the agenda. So before we start, can you tell me what's your understanding of NVR Act? What you know? If you share your ideas in the chat. That would be really great. So it's a, when I say it's a source document. Great. Is anyone else? I'll wait for a few seconds. Maybe we all need a coffee today. Friday morning. Nationally consistent regulator framework for VET. Underpinning legislation. Great, Carly. Okay. Thank you so much, guys. Source documentation and regulation. So, okay. Thank you so much. So what NVR Act is an umbrella law for all above standards. What it says, primary legislation giving ESQA its authority. And NVR full form is that N for national, V for vocational education training, R for regulator, and Act. You don't need to remember this nowadays because with the Google and stuff is easy to find it out. Governance, registration, renewal, audit, investigation, enforcement. So all those information is coming from NVR Act. It's a source document or source act. It defines the legal duties of CEO, PO, owner, and whoever controlling the registered training organization. It also the standard for RTO sits under the act. Every ESQA decision is based on the power on this act. So imagine that there are so many things that sometimes coming up, which is not written in standard for RTO. Let's say canceling the certificates that you're seeing currently nowadays. More than, I think, around 30,000 plus certificate being canceled. So all those things being part under the NVR Act and ESQA or any regulator exercising that power as required. What sits under the NVR Act ecosystem is standard for registered training organization that covers all three parts. So outcome standard, compliance requirement, credential policy. Fit and proper person requirement. That's section 20 to 26 of NVR Act. Financial viability risk assessment requirement. Data provision. So, okay, what type of data that require, what need to be submitted, how that need to be recorded, where that going to be submitted, how long you need to keep the data, all those information aligned to it. General direction and condition, that could be that, okay, you need to retain the evidence for 2 years, or you need to retain this certificate for 30 years, or for certain amount of time you need to keep this, or all those general direction comes under this section 28-29. And then audit and informants power, part 6. So how audit going to conducted, what kind of enforcement needs to be done, do they give an extra chance to submit the evidence or not, all the audit and informants related power, it sit under the section 82 to 97. ESOS framework, if you are a CRICOS provider, it's also ESOS Act 2000, National Code 2018, ESOS regulation, and 2026 integrity reform, which is not passed yet, but it likely to be passed next year. And then it's going to give more power and transparency to the regulator. And also there are some other state and national related legislation like privacy, WHS, fair work, copyright, disability standard for education, and state child safety and placement law. So even if you sometime, let's say a 9B provider and CRICOS, we need 9B, where this come from, it's all written under the NVR Act. When we read that we get the idea about it. So that's just kind of a idea that you get what sits under the NVR Act. ESQA core power, under the NVR Act actively using. You see, number one, this is what we started usually seeing now in 2025, the civil penalty fines used for the false information, non-submission of data, and breaches. What we have seen this year, that how many of you are in vet sector that ASQA hasn't exercised this power before? How many would you agree with me? Because this year we're seeing now it's going into fines. We never seen this sort of thing before. And the thing few of the thing I have seen it personally as well, because then the people contacted us, and one of the RTO did not submit the initial data, witness data, and they got the fine of 19,800 for not submitting the data and the penalty and things. You also get, if you misleading marketing information, can also you get the up to 6,600 to up to 50,000 fine as well. How ASQA calculate this fine is also based on the point that they have created. So this particular, for example, marketing related misleading information has sit into, let's say, 30 DMA point, and every point has $330 or something. I have created a detailed blog around it, so we will send it to you as part of it, so you get the idea. And you know, the interesting part is when we see the RTO website, more majority of time, sometimes you find the information that could be misleading section. And if ASQA wants, they all get the fine as well. So what I strongly suggest that whatever is your front face, whatever available on the public side, you just need to make sure that it's accurate and current. Otherwise, it can also lead to a fine as well. Qualification cancellation. ASQA may cancel the certification if evidence is not sufficient or invalid. This is also we seeing in 2025 majorly is ASQA is exercising this power, and not only canceling, they're going back up to 2 years or 3 years as well. So that's why you see around 30,000 plus certificates being canceled. And every single student been emailed by ASQA that we are intending to cancel the certificate, notify us, because the relevant RTO unable to deliver the training and assessment properly. So, and what we're seeing that this is likely going to be increased next year, because that's what their due diligence identify, that there are certain provider not doing things properly, and there could it face. And now if you see from a new SRTO standard, we need to keep the data for 2 years. So this is something which we're seeing quite increasing probably next year even more. So as RTOs need to be mindful. Registration, suspension, and cancellation. If there is a greater risk posed to the student, then there could be a cancellation as well. Fit and proper person enforcement. We seeing nowadays that because they have their own detailed intelligence setup, the regulator know each and everything now. They're mapping each and every profile. And if any CEOs or director or any try to avoid this situation, because now they're checking the fit and proper person properly, it can create a problem. So make sure that your fit and proper person, or whoever you're hiring as a CEO, owner, or even a managers nowadays, ASQA is asking for fit and proper. Under the new standard of governance section, anyone who making a decision or responsible for managing, they all can ask for the fit and proper person. And it's RTO responsibility to make sure they are fit and proper. And maybe Peter can cover up in more detail about this fit and proper person in his slide. Financial viability power. We have seen this year majorly that asking for the 2 years of bank statement, profit and loss, cash flow, or all the account related documents by a regulator. So further, and then they're raising the concern if there is a certain transaction doesn't make sense. Enter monitoring and investigation power. So ASQA can enter your premises, compel evidence, access your LMS, SMS. They have the power to do it. And the power is that they don't need to notify RTO. They can come anytime. Some of the other additional power, someone's to attend interview. If there are any CEO, staff, or contractor not attending, they can summons that as well. Digital access or copy power. ASQA can get your all the digital access, LMS, SMS, cloud storage, email, drives. Non-interface order may order RTO staff to stop delivery of the assessment as well. Enforceable undertaking, binding agreement forcing RTO to fix non-compliance or face cancellation. So we have seen sometime that they're putting into a binding agreement that, okay, within a 6 month or 8 month, we will come back and review everything. If this is not been done, you can face many challenges. And probably Peter might also explain in much more detail about this as well. Revising registration decision. ASQA may reopen or reverse approval when there's new risk intelligence emerge. We have seen that RTO been approved for 7 years of renewal. And within 3 months, the RTO got the audit again. And then they got cancellation notice. So that also happens. It doesn't mean that you got 7 years of registration, then nothing gonna happen. Public disclosure of decision. ASQA may publish sanction, fine, suspension, cancellation information on the public forum as well. Sector ban, permanent exclusion of owner, CEO found if they're not fit and proper person. So that also can be exercised, that ASQA may say that, okay, public do not have a confidence in certain people to be as a CEO or a fit and proper person. So I'm curious to know, is there anyone has an experience of any sort of stuff and maybe share or willing to share their story or knowledge so we all can learn together? So maybe even if you want to say it, I'm happy to even turn on your microphone as well.
You can raise your hands virtually in case you want to share anything specific, and we will make sure that we turn your mics on so that you can directly interact. Okay, we have Nikki. I guess she has got some experience, Ben. So just turning her mic on. Over to you. We also have Shelley with us, allowing her mic as well. Yes, Ben. Yes.
Yes, so Nikki.
Hi, everyone. Thank you very much. This is really helpful information. I guess for me, I just want to talk to a scenario on professional development and currency for not just trainers, but also for the CEO. So we're talking about fit and proper person, CEO, and anyone making decisions about and for the RTO, and how in the new standard it very clearly outlines, highlights that it is necessary for anyone making those decisions to be aware of the standards, to understand them, and to engage in ongoing professional learning. And so this is something that's been a bit of a challenge, I would say. So having the immediate trainers and assessors, they're very well versed in that. They're constantly engaging in professional development, but any others, it's something new to them. And so this is the current conversation. I guess it's just more of a story share with all of you and highlighting how it is important. It can be a challenge, but knowing how important it is and knowing that it does add value to the RTO. If everyone is on the same page, we hope that, that's the goal, that we are here to support our students and that we don't compromise on the integrity of the training packages too. So I don't know if that's something that's helpful, but it's a conversation, an ongoing conversation.
I can, not wanting to cut across you, Ben, it's Peter here. Can I address some of that?
Yeah, why not?
Hi, Nikki.
Hi, thank you.
Look, you're absolutely right. It is a concern that sort of emerges from the new standards because the clash between traditional corporate governance and the RTO standards that we were kind of experiencing before this reform is going to be even more profound now, I think. So you look at an institutional RTO, or you look at the big companies that have RTOs as part of their corporate structure. There's no way the whole board of that company knows the RTO world. Often we find that the CEO is the big boss who doesn't even have any knowledge of the RTO space, and the person with effectively the high managerial agent is that's actually running the RTO within these big structures is somebody that's not involved in senior management at all. So that's some of the challenges that we see. What I'm hoping is that ASQA's discretionary powers will be used in a logical way going forward, and they'll be able to do their regulation around the effective CEO. So the person who's not just the person noted down as the high managerial agent or directors or CEO, but the person that's actually operating the business or actually running the RTO. I'm hoping that we start seeing some direction from ASQA on that point, because I am a massive advocate for governance and proper corporate governance to be applied within the RTO space. But as you broaden that list of people who are subject to those NVR Act restrictions or that burden, and the burden that's created by the standards, the more broad you make it, the more chances there are that people that are not involved in the RTO at all are making those decisions, which is something I want to avoid.
Yeah, I think great.
Peter. Yeah. Oh, sorry,
great.
Ben, go on.
Yeah, great, Peter, for adding. And Nikki, thank you so much for, adding your knowledge and information. I can see in the chat, a lot of people thumbs up that you've done everyone in this. That's what we're trying to cover here. And as Peter said, that we will see how ASQA respond to this and see how, if the CEO is not 100% knowledgeable in the VET sector, but at least the CEO has someone who can take over the operation and stuff, and would be interesting to see how that ASQA respond to that. Is there anyone else? We had those, you said one more person who want to share it.
I guess Shelly raised her hand, but I guess we're good to go. We can move ahead.
Okay, great.
Yes.
Thank you so much. So why this NVR Act matter, and why more in 25-26? What is changing in what when I observe, I was reflecting 2 days ago about that. Okay, how can I add value to this session? And been gone through like almost 50, 60, 80 plus audit in 2025. What we're seeing now is that the regulator approach is been changing toward more intelligence, and rather than doing one way of audit, they're doing more intelligence first, and identifying those RTOs who may likely gonna have a problem, and then enforcing this decision around it. So that's what we're seeing a lot, and what we're gonna see probably looks like next year is those cancellation, those penalties, and all those things looks like gonna grow more, because when ASQA is going to broaden the horizon. Plus, the new standard just in place from 1st of July So now it probably the next year, ESCO expect that now RTO should have been ready and probably more adding more scrutiny of checking it that, okay, is that RTO doing things properly? For example, the governance structure, which we are discussing about it. So that's what we're seeing. New standard to the deeper testing of governance and evidence. That's what we just discussed about it. ESCO using stronger powers, fine, cancellation, fit and proper person, which we usually didn't see in the previous year. So regulator utilizing those power, and I'm also okay and been advocate of it, because if the RTO is doing completely wrong and not doing the right thing, they should be. But now the problem with the quality RTO who is not able to retain those evidence, they can be into that loop as well. So that's why the RTO who actually want to do good thing, that's why we doing this sort of session, so they can aware of it and retain the relevant evidence. So then they will not be in this part of new fines and cancellation and all those things. So that's why we want to do this type of session and preparing RTO for it. CRICOS integrity reform may increase the intervention power. So as I said, the CRICOS integrity reform likely to going ahead next year, which gonna give more power, more transparency as well. CEO will be directly tested during the audits, as we just discussed that, because CEO also do CEO declaration, annual declaration of compliance. So indirectly CEO telling that, yes, we are compliant here. Yes, we are non-compliant here. Yes, we compliant here. And what ESCO might say, you have done all the things, you are compliant, not compliant, all those things. How did you make that judgment? Yes, you shouldn't aware of every single thing, but you should know what's going on in the RTO. Otherwise, how will you be able to even sign off on the annual declaration on compliance? So maybe, Peter, that's a challenging conversation for the bigger RTO who CEO doesn't know about it. But maybe they also need to put at least some amount of time to understand a little bit that, okay, when you're signing off the document, how do you make that judgment? Or you at least you rely on the audit report and you read the audit report and say, okay, this is based on this. I have signed up this report or declaration. Okay, so my time almost done. So what RTO leader must do in 2026? Strengthen governance. CEO and manager must understand the system. Ensure assessment defendability. Make sure you keep the proper evidence trail, because if they ask your LMS access, SMS access, all this thing, keep in mind that you need to provide clear documents and clear data. Maintain financial viability at all time, because as I said, we have seen that they're asking for 2 years of transaction, 2 years of statement, and then identifying, oh, why this transaction, explain about why this transaction is. Ensure data accuracy. Make sure your witness data, USI data, attendance, if your policy say you're doing attendance, and if you're a CRICOS RTO, make sure your data is accurate, because when they checking an intelligence, they also check the data. And also for the CRICOS RTO, they also check the PRISM as well. Validate early and often, not just annually. Make sure you do a proper validation, not just an annual process. Other thing which we're seeing emerging in the audit across all of them, thank you, Vanessa, is aligning the system. And this is something I think we also working toward it, say how we can integrate that into it. Usually what we see in the audit that one document doesn't talk to other document, and probably you all agree to it. And what we're seeing there, they often start with the thesis, then thesis information doesn't align in the marketing. On the website, it might be something different. Then your student handbook is very generic, doesn't even say anything. If there is a course has a work placement, there's no information of work placement there. If the RTO is located in Perth, the student handbook says about Victoria. Then your timetable doesn't align, and actual timetable doesn't say anything. Your policy says something else, your processes say something else, and evidence is something else, and your staff saying something else about it. So as an auditor, when you ask certain questions, say, okay, nothing is talking to each other. And that's what we quite often. And what I would recommend every RTO, say, have your system ready first, say, have a process, train your people, and ask them to collect the right evidence, and then do the spot check every month. Okay, today I'm going to do admission check, and so on. I'm already above, so apologies, Peter. Be site audit ready. You see there are 120 plus site audit happen in 2025, and next year gonna be a more. Make sure you be site ready. If you guys all want, we will do one more session just on how to be ready with the site audit that regulator conduct. If we get sufficient yes, at least 50 yes, we will do another session just on this one. And just want to say thank you all of you for the amazing participation. And I think through this webinar, I also learned a lot of things from your questions. So just very grateful. And now I'm passing it to Peter and look forward to learn from Peter as well. Thank you, Peter.
Thanks, Ben. Hi, everyone. Ben was absolutely right. I am a technology not savvy. So if I get anything wrong in this presentation, someone just scream at me or they'll fix me here. So thank you for your time, everyone. I acknowledge that we're coming from all over the world with regards to today's presentation. I acknowledge country for those people that are logging in from all over Australia. If you bear with me for a moment, I'm going to start my presentation, and before I do, I just want to also advise that this morning an email was sent to a number of RTOs from the PRISMs, from the Department of Home Affairs. So I went through PRISMs from the Department of Home Affairs regarding the implementation of certain changes to the operation of PRISMs and to the ESOS Act. Not only the reforms, but also what the reforms will mean in practice. And I propose to go off script and to talk about that later in the time if I have some time. But in the meantime, I'm just going to open my screen and share it for a moment while I've already apologized for my technological unsavviness, so bear with me. Can everyone see this?
We can see that. Yes, we can see it.
Excellent. All right. If for any reason it's broken or something else comes up, someone just scream at me and I'll fix it. Well, look, everyone, the purpose of this presentation is to go a little bit deeper into the way that compliance operates in practice. It also has a purpose to inform the operations and the interoperability of the NVR Act, the ESOS Act, and the standards, and basically running an RTO in a compliant way. I've been operating and working in the space for more than 15 years, and I would know many of you. I'd say we've acted for probably more than 500 RTOs by the end of this year over that time, and higher education providers as well as schools and universities. My specialty in legal practice is in commercial law, but over the last 15 years, I have become an RTO person, probably because I got sucked into it many years ago. But it is a very unique area of practice, and it is a very specialized area in terms of how regulation and compliance works within the context of a commercial business. RTOs essentially are businesses, and we sign fit and proper person declarations, and we sign financial viability risk assessments on the basis of profitability and sustainability. And that applies whether you're an RTO that's a company that's for profit, all the way through to an association who's running an RTO for the benefit of your members. Ultimately, the central aspect of this is that the RTO business is and must be sustainable. Now, we've been talking about regulation, and we always talk about regulation in the RTO space. In the last 2 years, what we've seen is the clash between regulation and policy. So it was always the case that ASQA had the power to cancel the registration of a registered training organisation. They could make a sanction, they could make decisions based on their interpretation of the NVR Act and their standards, and whether an RTO was compliance. The word was always compliance was used. Government was always a backseat passenger in this process. Government reforms were much slower and were not the incubating factor of our world being the NVR Act world, RTO world. That all changed with COVID, when government policy overtook everything else, and we started seeing very quick things like border shutdowns and reopening of borders, and then visa changes, and all these things happened really quickly. That's the interaction of when I say policy versus regulation. Regulation is ASQA, policy is government. Since then, and especially since the election of this current government in 2022, a completely new world has emerged where regulation has actually become slower than policy. Things like lapsing notices, things like the cancellation of student qualifications, the use of different regulatory tools by the regulator on instruction by the government. All these things are new in our world. And I have in the last couple of years been talking about the interfacing of policy and regulation. I'll go into a specific example a little bit later, but to just touch on it, let's look at lapsing notices that were issued to RTOs. Most of you would know that the RTOs must operate and must train students within a 12-month period, as Ben was saying in his presentation, in order to remain registered. The principle of this used to be, and this, by the way, this was a regulation that was operated by ASQA in its regulatory functions. So I have been in audits in the past where ASQA auditors said, you didn't train anyone this year. We're a little bit concerned about your financial viability, and we're a little bit concerned about how you're operating. And that's as far as it would go. And sometimes it would be an issue at the end during the audit. So there was a regulatory power to conduct regulation on the basis of operations. In this new world since 2022, and particularly since 2023, and the implementation of lapsing notices, the provider that has not trained a student within 12 months, within any 12-month period, commencing the 1st of January 2023, is automatically lapsed in its registration. And I'll talk about the way that that reform interacts. But this is something that even ASQA was surprised about, and the people that and the colleagues that I had within ASQA that I talked to about it found it a very difficult form of regulation to operate, because essentially the orthodoxy within our world before that was, if you couldn't operate in a compliant way, don't train. And that changed in 2022 and 23 and 24 to you now must deliver courses because of this new policy change that was implemented by the government. So that interaction of policy and regulation and those changes and the clash between those two has been dictating the way that we operate, the way that we conduct not only compliance work, but legal work within the compliance framework. In the meanwhile, there's been a number of regulatory flashpoints in the last year that I want to talk about. Obviously, cancellation of registration of RTOs is increasing. The use of their ASQA's use of sanction powers of different kinds, suspension, written directions, and others, is also increasing. In some instances, I'm a supporter of a much broader regulatory use of the much broader regulatory tools that ASQA uses. Before 2019, it was always just a cancellation. There were many more cancellations than we have today. If there was a non-compliance, they used to have this principle of a serious non-compliance, and cancellations would be far more common than they are today. Today it's broader. They're using suspensions, they're using other tools. However, we've also seen the use of things like the cancellation of student qualifications, which commenced around this time last year in a bulk way. These are powers that ASQA always had, but they started using them in a far more aggressive manner. And of course, in some instances, it's justified because we've seen colleges who were not doing any delivery at all, or that's the allegation that was made, and subsequently was shut. The college was cancelled, and lots of students were in the market with qualifications that, in some instances, they should not have had. The use of 62 notices and notices to produce is the use of ASQA powers that have been implemented in recent years, so the last 2 years, in a way that was not really common in the past. So I don't want to dive into the law around it specifically, because it will bore everybody, and you'll all end up looking as old and cranky as me. But the principle that I want to go into is that ASQA has the power as a regulator to compel a registered training organisation to do certain things: provide documents, provide assistance in an investigation, and this is an obligation that an RTO has. ASQA also has the power to issue a notice to attend ASQA's offices to conduct an interview, and non-attendance could be deemed to be a criminal offence. In the meantime, ASQA also has the power to compel a third party. This is not a third party within the RTO world, but any organisation. It could be your third party RTO delivery partner. It could be a data provider. It could be Google and Microsoft, to provide that information to ASQA as part of an investigation. Now, these are powers that ASQA had as a regulator, and they've had them for 10 years, but they're using them in a far more aggressive way now, and and as part of many more audits. So in the past, I would very rarely see the use of these powers except in the most exceptional circumstances. Now, even in audits that are actually quite benign, they're being used as part of their regulatory operations. So the implementation of the new standards this year saw another layer of regulatory compliance on top of these additional powers, which caused a little bit of chaos in the space, but primarily where we've seen the reforms most impact the way that providers operate is in that governance area that Ben mentioned earlier. We all know this question of critical non-compliance and non-compliance, how we need to avoid non-compliances. Today, on top of all these regulatory flashpoints that I mentioned, and I'll talk about ESOS breaches as a separate point at the conclusion because of these changes that just came in from the Department of Education this morning. But because of these reforms, RTO's exposure to regulatory impacts or regulatory problems have increased. The example that we gave earlier was about the use of corporate governance principles in the RTO space. And I am a supporter of this because an RTO should be an organisation that operates at a higher standard than just any other business. A registered training organisation has a national registration, and in some cases, it has the entitlement to create a visa for the Cricos colleges, but regardless, is held to a higher standard than just a normal business. I think that's correct. However, when you apply corporate governance principles like the duties of disclosure, the duties of financial viability, not the ASQA style of financial viability, the ASIC standard of financial viability, not trading while insolvent, while maintaining certain duties of disclosure, maintaining also directors' duties. You also need to then overlap that regulation, that standard Australian commercial law regulation, with ASQA's specific regulations around the NVR Act. These are matters that have not really been ventilated yet. They haven't been tested properly in the tribunals, in the big appeals that are happening in terms of the way that government's implementation works. I just want to talk about things that happened in the past because 10 years ago, there was a big spike in RTO appeals. And the big problem was bad management of RTOs. The RTOs were being poorly managed, that was being run incorrectly. And the standard procedure that we would undertake back then would be to completely reform the internal operations of the RTO. Get a new CEO, get a new director, get new operations staff, and then present to a tribunal or to ASQA this completely reformed organization. And it mostly worked because the principle was if you could show a reform had been undertaken within the organization, then you'd be normally given the opportunity to prove. These expanded powers of ASQA, on one hand, coupled with the reforms that have been undertaken and implied through the new standards, broaden the list of people that, in the old language, were high managerial agents in such a way that people who may not reasonably need to be expected to understand the operations of our world, our RTO world, which is not just the NVR Act, but it's much broader than that. People that should not ordinarily need to understand those operations of the world are now being put in positions where they need to. And that creates burdens of cost to a provider that were never really factored into. And by the way, they're not even going into the financial liability risk assessments. But people need training in directors' duties. People need training in continuous disclosure requirements. They need training in the financial liability within the ASQA world and outside the ASQA world. And these matters are now starting to get ventilated in the audits that I'm seeing because good governance now starts all the way from the top of the organization, shareholders and directors, and expands all the way down to, for a larger organization, mid-level trainers who have no say in management, but may just operate and run certain courses as effectively as subject matter experts within businesses. So it's a far more expanded governance environment, and that creates a training burden. So what I've been saying to people is that you must have a proper board. You must have a proper management committee which has minuted meetings routinely. So weekly or monthly meetings that get minuted where there's records kept to show that the organization is actually operating in a compliant manner, but to also show that the record keeping and the governance of this organization is being done within best practice from an ASIC and Australian corporate law perspective, not just from the RTO world. So,
hey Peter, sorry to disturb you. I think everyone is seeing the first slide. Is there meant to be?
I'm trying to see, where am I? Can you see this now? National Vocational Regulator Act.
No, I think you need to stop sharing and just share it again because it's not moving at our end.
Not moving at our end at all. Okay.
Maybe stop share and try again.
But the information Peter was giving was so much relevant that even the slides were not needed, though our team worked really hard to make those slides. So we will be sending it after the presentation as well, but that's some really good information.
Yeah, it's a great information. And I emphasize on the last point that been mentioned is that we need to keep the record, like all the meeting minutes, the informations of continuous improvements and all those things. Why this is important? Because when you make it on the last point at the time of audit, now ASQA has also trained the auditor to see that, okay, how to check the property of the document, where this document is created, who is the owner, how this done. And now there are sophisticated software available that you can even see that, okay, when this wasn't even modified. So that's why it's important that, okay, we discuss this continuous improvement today, better to record it today in the meeting and better to do the right process today rather than at the time of audit, you're doing all this. Oh, we did this meeting, but we don't have that meeting minute. And like I said, I am also being part of the same problem. Okay, I have been there, done there, all those things because oh, we're too busy to do it, or there is no one to there. But now use AI software, at least 70-80% they will take up the meeting. You tell them at the end, this at least you have some record there. What I find it, the majority of RTO want to do the right thing. And they're doing it as well. I've been part of the meeting where we discussed that, oh, this assessment marking is not working. This is how but that was not captured. And that was not, because if you're not capturing, it cannot be implemented. Because after the meeting, everyone busy with their own work. So what I suggest that the most important thing is to keep those records. And we are seeing in regular audit, they're saying the property, oh, this document was created just 2 days ago. So how that was in 5 months ago in your continuous improvement. So those are the things that matter a lot. What I think, until Peter joined, Mahi, can we start some questions in the meantime? So we'll just answer the question. And also before even that, I'll maybe just briefly tell everyone what the site visit is about. So you're seeing that majorly in 2025, ESCO has conducted, I think if you refer their annual report, ESCO annual report 24-25, 120 plus site visits been conducted. And out of 80 plus was just unannounced. And if unannounced meant that you need to be prepared every time. And what they usually want to check in the site audit is that your timetabling properly. Is your student attending the classes? Is you delivering according to the timetable? Maybe I interview the student that, okay, is this, what was the previous unit you studied? If there any practical, okay, what time did you access the practical, or how many hours you did the practical? And then I talk to the trainer, and then I'll try to align those information with the documentation provided. So, and then also they want to see that is the RTO is resourceful. If they're saying we have a simulation for carpentry, do they have all the resources there for the number of students that they're doing? So that's why those site visit, and what we're seeing that the outcome of the site visit is significant that received. What we're seeing in the next year, it's gonna be many more site visit there. Because as you know, that now ESCO work on more intelligence and collecting the feedback. And when they find it that something doesn't seems right, they will go and do the site visit because they just want to check it out, make sure everything is okay. And then after the site visit, if whatever outcome of the site visit, that will define the further steps. That could be a sanction, that could be a non-compliance, that could be a further audit, there could be many other things. And that's why I always say that make sure that you and your RTO is site ready. That doesn't mean only a manager, CEO need to be prepared. Means your trainer needs to know that, okay, where is the session plan? Is the session plan customized? Is your training and assessment strategy given to the trainer? Because how many times, and I've been in the same boat, like we do the TASs, but we don't give it to the trainer. How many agree with me? Just say yes or no, thumbs up, thumbs down. And that's happened, you know, and I've been part of that as well. And maybe if you reflect, so now they're asking that, okay, do you have the TASs? Is the TASs given it to you? Or at least that the structure of the delivery been informed to the trainer or not? So what ESCO is trying to match that your TASs and the training and timetable is actually happening in reality by talking to the student, by talking to the trainer. And I'm going to match the trainer feedback and the student feedback and your documentation and your student support information and your manager information. See that everything is talking the same thing. And I think last 2 weeks before, we did a site visit for one of the client, is a big client, and we gone there just as a proper site visit, and just taking a photo, doing all those things, talking to a trainer, talking to the students, asking those questions, making sure they have sufficient resources. And those things is actually really important. And sometimes as a CEO or a manager, they don't have a clue if there's a big organization. And that gives them an idea that, okay, we need to improve. Because what I find if ASQA improves and doing a better intelligence as an RTO also need to improve in their processes and system. So do you want to start question?
Yes, I was about to say.
Arpit, any update from Peter?
Just to update, yes, Peter is joining. He's having some trouble with his internet connection. We just had a word with his assistant. He is joining in next 2-3 minutes. Meanwhile, Ben, you can continue. You're also the best person for NVR Act, and we'll be glad to hear from you. Yes.
Yeah, so maybe Mahi, if you can start with the question, that would be
questions. Good. Yes, there were some questions were coming in, and I'll start with the first question that was from Vanessa herself, and she was asking if the regulatory calls it a performance review and the act call is audit, is it the same or is it the different?
Yeah, it's the same.
It's the same, right?
So, it's like a fancy word of audit is the performance review, so it doesn't look like audit.
Makes sense.
They don't call it audits anymore in that way. Though the narrative remains the same. It's effectively the same thing.
Yeah, Peter is back.
I'm back. Sorry, hello everyone. Sorry for this technical issue. I don't know what happened to my internet.
It's normal. It happens sometimes.
Yeah, we can hear you now.
You can hear me. Excellent.
Peter, I'll tell you the story. It happened to me in last 2 session, and I was fully frustrated about it. So this session, it didn't happen to me, so I'm glad. But that's happened. That's normal.
It's just all fun and games. As long as everybody can hear me, what I propose to do is I don't want to take time away from your questions because I know that lots of people have got some questions to deal with, but I'll finish my presentation quickly and then open it up to questions so we can go through. Is that okay with everyone?
Absolutely fine. We're good.
All right. So bear with you. I'm going to share my screen. Now, I expect some people had some difficulty getting accessing the thing, but I'm going to just try again for a moment and share and see how I go. Everyone can see my screen?
Yes,
we can see it.
Lapsing notice. We can see
excellent. All right. I'm not going to take too much time on these points. The central point of today's presentation is that we're living in a world today in the vet sector where policy and regulators are clashing, and the lapsing notices is the best example in my view. And during the implementation of the lapsing notices, so if people don't know what the lapsing principle, how it worked last year, in around March last year, following the release of the VetMIS data, providers that had not operated for 12 months or not enrolled any students or trained any students in the 12 months of 2023 were issued with a lapsing notice. And effectively that meant that you had 1 month to prove to us why your registration should not just come to an end. And ASQA had the only power that ASQA had to conduct regulation around this point was to extend the measurement period by up to a further year. And that's it. No ability to undo its own decision, nothing else. It was bound by the law by the legislation that had been done. So basically about 400 or so RTOs were actually lapsed in this way. And the only way to undo a lapsing notice was to establish to ASQA, and ASQA had the discretion to use this, that the provider, we had to give good reasons as to why we hadn't done delivery in that time, and an undertaking that delivery would proceed afterwards. Now, everyone knew before 2022 that the smart thing to do if you couldn't be compliant or you weren't financially viable, which equals compliance, was not to enroll in particular courses and not to enroll in RTOs. Shelf companies, shelf RTOs are not the risk. It's badly functioning RTOs that are the problem. So this, and by the way, the people that I have spoken to within ASQA, and these are very senior members of the ASQA team, were as equally bewildered as I was about this process. I have to say, ASQA was really understanding at this time. We had some fights. There were some conflicts around this issue with ASQA, but overall, I was pretty impressed with how ASQA worked. There were some issues with it during the time, but it was not as bad as I thought it would be. So in this new regulatory environment, where regulator and government are kind of in a race for their own versions of regulation, we're seeing a different kind of outcome for RTOs, and this affects profitability and this affects sustainability sector-wide. So obviously I've seen delays in approving scope extensions, though it's been getting a bit better now. Definitely delays in approving registration. And today's notice that came out from the Department of Education is a proposal to mandate that any RTO that's registered has to deliver to Australian students for 2 years before it can apply for CRICOS registration.
Yep.
Which I think is ridiculous. And I'll talk about it later, but I think it's absolutely ridiculous because a CRICOS RTO is completely different in structure than an NVR Act RTO or even a local RTO or even a funded college. Those three businesses are becoming even more different because of ASQA's own legislation and regulations, which I agree with. You want an NVR, you want a local provider to focus on being a local provider. You want an international provider to be structured around being an international provider. This thing about delivering to Australian students is completely ridiculous. But these delays about improving registration are continuing. There's been ASQANet issues that everyone knows, which thankfully it's changing. ASQA has itself announced the end of ASQANet, and they're saying it's going to happen over Christmas and New Year's. I doubt. I expect if we give them until the 30th of June to get rid of ASQANet completely, I think we'll be doing well. But ASQANet itself has caused lots of difficulties to providers, particularly around audit time, because if a provider is under audit or under any form of sanction, even an intention to make a sanction, ASQANet freezes automatically. It's part of their compliance and regulatory regime. But the problem is often things happen in RTOs which need change. So there has been a reluctance to settle cases in not the AAT, Administrative Appeals Tribunal, which has been reformed into the Administrative Review Tribunal in the last 2 years. That reluctance, which I'll talk about in a moment, has been ongoing and is something that needs addressing. In the past, most cases in the tribunal would settle without needing to go to hearing. In last year, particularly, it was quite difficult to get things settled in the tribunal, even when there was no more compliance-related activities necessary. There is a higher sensitivity to historic non-compliances and a much broader use of sanctions, which translates to less cancellations, but more deregistration, often voluntary, of a college that's just not viable to operate within a compliance framework. We've also seen an increased use of suspensions or part suspensions and scope of scope of providers while things are happening. Things that are logical in my mind, but there still needs to be I think, more flexibility, even more flexibility in the sector in the way that regulation is conducted, given these increasing pressures that providers are under. Now, this slide, this issue about CRICOS RTOs, the impact of the announcement from this morning is that everything that you see here, delays in initial registrations, more difficulty in obtaining registration, higher focus on enrolments, a reluctance to continue registration of shelter colleges, initially lower profitability and less CRICOS RTOs. The new environment, if all these reforms are actually implemented, and as Ben was saying, if the proposed reforms to the ESOS Act are implemented, this is going to get much worse for CRICOS RTOs. The viability of Australia's international education sector is predicated on a well-regulated market for well-operating RTOs. And in an attempt to get to the agents, and there's been conversations about how agents are going to be monitored now. In an attempt to monitor agents, the pressure that Crikos providers is under will have serious impacts on financial viability. And I think we'll see far less Crikos RTOs entering the market and remaining in the market. It used to be the case that a Crikos RTO was viable even with as low as 50 students. That's not really going to be the case going forward, I think. I think Crikos providers will have a much higher minimum number of students that they'll need to achieve, which means that the operating costs of Crikos colleges is far higher. So in this risk management world, these reforms have translated into a high risk environment for the smallest providers. So this is the concern that I have as a practitioner in the space. But ultimately, the way the compliance reforms are translated to in the way that ASQA conducts its regulation, you've obviously got to demonstrate commitment and capability, the old principle of commitment and capability in the delivery of quality vocational education. Informing ASQA about an event likely to occur that would significantly affect the ability to comply with a VET quality framework. Well, the interesting question is, and I have been cheeky with these points. For example, today's announcement by the Department of Education about ESOS Act reforms technically requires that all Crikos RTOs inform ASQA that if this event occurs, it's likely to affect their ability to operate in a compliant way, because it will directly affect financial viability, which is an ongoing compliance obligation. So these are the inconsistencies between the reforms that we've seen and the way that they're expecting us to operate the RTOs. I am hopeful, and I have been impressed and surprised by how ASQA has operated within the context of these reforms. I think it's been reasonably okay, but there are these ongoing, what I call continuous disclosure requirements, pressures that are constant for the industry. Ensuring third-party arrangements continue to reform. And in fact, I need to change this slide because the reforms mandate far deeper into the way that third-party interactions between third-party providers work. And we're providing information or VET student records to ASQA when an RTO closes or on ASQA's request. Electronic file management and data retention is going to be, in my view, the most important aspect of regulation next year. The mandating reporting requirement and keeping records and the style of records that are kept have been central to all of ASQA's cases in the last year about how they conduct their regulation, getting the records to ASQA, their processing of student records, particularly academic records. And I think that, and you'll see that a lot of the cancellation of student qualifications matters, where the college itself was cancelled and then their students' quals were cancelled. These issues that were made worse by the fact that the college could not provide the education evidence, the evidence that the students did any education at all, because files either could not be found or had been destroyed. So I think there'll be a lot more work to be done on this. The dust hasn't settled with these reforms as yet, but student records and training and assessment records, I know the new rules dictate 2 years. The argument now is whether providers should keep them for longer or not. And then we turn to the last part of today's presentation, which is appeals to the tribunal, the Administrative Review Tribunal, in the event that ASQA's internal review processes that you undertake is unsuccessful. So often often a decision from ASQA is made and you'll be happy with it, or you'll be able to deal with it. A sanction, let's say a provider is issued with a notice of suspension, and if you do certain things, then that notice of suspension goes away. Many decisions by the regulator, ASQA, like any other aspect of the Commonwealth, can be appealed to the federal tribunal system. in this case, the Federal Administrative Review Tribunal, which has the power to overturn ASQA's decisions. Now, I give a whole different presentation about sanctions management and managing in depth the way that appeals and ASQA raids happen, and I'm actually planning on hosting a masterclass in my office around this very point. But to just touch on the way that the appeal process works, because often people ask me, what is it that determines a successful case in the tribunal or an unsuccessful case in the tribunal? And let's give an example of a classic tribunal case, which was a notice of cancellation to a provider, the kind of thing that no one ever wants to receive. But sometimes it happens. ASQA sometimes makes decisions where the only option is an appeal to the Administrative Review Tribunal. In such an example, the first thing that a provider needs is to obtain a stay of that decision. And the tribunal has set out in a judgment handed down many years ago, 2009, 6 points that determine whether a stay of the decision will be granted. So a stay of the decision effectively presses the pause button on ASQA's decision coming into effect. So many of us will, if anyone has seen an ASQA sanction, it's an email that comes from ASQA that includes a notice of decision and a statement of reasons. Statement of reasons is effectively like an audit report, but the notice of decision is a letter from ASQA that says, I have decided to cancel your registration. And it provides a date where that's effective by, normally about a month after that date. So the most important thing for a provider to do once it receives that is to formally appeal through lawyers normally, so formally appeal to the Administrative Review Tribunal and seek a stay of ASQA's decision. And effectively, the tribunal runs a mini hearing around whether it should use its power, and it's entirely discretionary. It's basically within the power of the tribunal to do so, to apply a stay over ASQA's decision and prevent it coming into effect. And these are the tests that it uses. The prospects of success, in other words, that the case is not hopeless, the consequences for the refusal of a stay, the public interest, which was very relevant when we talk about student cancellation and the cancellation of student qualifications, the consequences for the respondent. The respondent in tribunal cases is ASQA. Applicant is the college, the respondent is ASQA. Number 5, whether the application will be rendered nugatory, which is my favorite, which basically means that if a stay is not granted and the cancellation comes into effect, in 6 months or a year later, when the tribunal comes to determine the final hearing of the matter, will this business be around? Will this college be around? Will there be any point to an appeal happening if you've shut the whole thing down and all the students have had to go somewhere else and the entire business effectively has run out of money and steam to operate? That's what rendered nugatory means. If there's no point to a final hearing if a stay is not granted. And then any other matter. So the principle here, the reason that I bring this up is because when you get a cancellation and a serious sanction from ASQA, you don't have time to rebuild your infrastructure internally. Good governance, good financial management, and a good infrastructure in terms of a team inside and outside your business are what makes the difference between surviving this and not surviving this. We never want to be in this position, but some providers find themselves in these circumstances. And the tribunal itself rewards organizations that have good record keeping. Be up to date with your BASs and your accounts, because in that point too, the consequences for the applicant of the refusal of a stay, that is a financial question. You need to be able to answer that by saying, well, here is my financials for every month of the year, for every quarter since I was founded. This is how much money I need to operate. This is how much money I need to stay alive. And if I have less than that, then I'm going to die. That has to be a financially sound argument. And the cases that I have run, I've run more than 100 stay applications, both myself and with barristers. And the overwhelming outcome of tribunal cases is that companies that have good record keeping are rewarded So if you can show, here are my financials from last year. This is what happens if you cut me off from new income. Then it is very important. The other part, and this is especially given the pressure of the new standards, is good governance. I am as I mentioned at the beginning, I am a big advocate for proper boards and advisory boards and governance committees in all RTOs, because we are held to a higher standard in our world. And for that reason, having sometimes external directors, people not involved in the operation of the business, who you pay to come in. You have often I sit as a secretary to these boards and provide advice. But the principle is that you have an ongoing governance structure, and you can show ASQA or tribunals or anybody else, if need be, your minutes of operation, so you can prove that your decision making is thought through and has a process. So these issues and these matters that come up when you're in the tribunal process are really important, and it makes the difference between winning and losing. So this is just the process that we go through during an ASQA review, an ASQA audit of any kind. I still call them audits. ASQA changes the names of them all the time. I always call them audits because that's what they are. You are being reviewed by a person outside your business, and that person has the power to make a decision that will affect your business. That's an audit. So normally a delegate of the commissioner or delegate of the CEO of ASQA will conduct a review initially. Let me use my example of cancellation. After that review is concluded, a decision comes out where you cannot appeal externally yet. It is a decision that can be subject to internal review or internal reconsideration. So that the provider will undertake effectively like another review by another person, not the first. Normally, it shouldn't be the first person that did the review, and then undertake internal reconsideration. Now, in some cases, ASQA will write to a provider and say, I intend to make this decision. And if that decision is made, you need to seek a stay internally from ASQA. So you need to seek ASQA not make that cancellation decision while it's conducting its internal reviews. One of those things one of the reforms that I saw in today's email from the Department of Education is that they're proposing to change the minimum timeframe to respond from 90 days to 120 days. So you can imagine that'll put a lot more pressure on people to get their act together, and it will be far worse if ASQA uses its power to not grant a stay of a decision while it's conducting an internal review. So these are matters that are dealt with at that internal stage when you have a delegate of the CEO undertaking an audit. We go through the internal review, and ASQA then makes the decision to either overturn its decision or affirm the original decision. And if it affirms the original decision, you've got to pay the fees. They've got to charge you the fees. You have to pay their audit fees. But then we're in the tribunal, and you have to make an application for a stay, which I discussed earlier. Once you're in the tribunal, the first step that's undertaken after the hearing of a stay is ASQA's obligation to provide documents under Section 32 of the ART Act, which is documents called tribunal documents. Everything they've used to come to their decision. Often we learn a lot from these T documents. Then we, as the applicant, provide our evidence. Then ASQA provides its evidence, and hopefully the matter either goes to a conciliation and it's resolved, or is listed for a final hearing where the tribunal will determine a decision as the decision maker. So it sits in the shoes of the decision maker and will remake the original decision. So the tribunal process is arduous, it's difficult, and is often problematic. But the reason I wanted to bring it up and I wanted to show today this process is because it is what we steer around in this space. It is what guides us, and more importantly, it is why I'm such an advocate for ongoing governance and compliance to be central to the way that we operate within the space. So I'm happy to open it up to questions, and I could talk all day about this stuff. But thank you everyone for your patience, and thanks Ben for hosting. But if anybody has any questions, fire away.
Yes, thank you, Peter. We have some question already here, and which I've noted down. One question is from Ray, and what he was like asking is, what rights do students have if their RTO has been deregistered and their qualification is no longer valid?
Is that to Peter, to Ben?
It says Peter and Ben for both of them. So whoever can answer that question.
What a way to start. You want me to start, Ben?
Yeah, that's fine. I've been dealing this quite a few recently, so and then Peter can add on as well.
Yes.
It's unfortunate that when the RTO registration cancel and the decision is made that 2 years of qualification now not valid. What the first step is that when ESCWA is canceling the RTO, asking for all the data. So they're getting all the student information in their student management system everywhere, making sure that they have been submitted to a witness, collecting all the information. Then ESCWA has an internal team to send that email to all the students. Said, okay, we are intending to canceling your qualification. For this qualification, this is what you have done. If you want, you can respond to this, and we are giving you this link and the password to prove us that you have been engaged into the study. And if you respond to that, and if you have the documentation and thing, then their internal team will review, and then they get back to you. So that's the student has that thing to get back to ESCWA. And Peter can add on more on top of that as well if you want.
The recourse for a student in the well, there are three aspects. The first is the recourse for a student should their qualification be cancelled, is to appeal the cancellation of the qualification to the tribunal. Now we've seen, unfortunately, lots of students go it themselves, and I'm acting in a few student cancellation cases, but overall they're failing because the students are not providing enough information. And there's a couple of judgments that have been happening that have come out even recently, which are not in favour of student cancellations. But the recommendation first is to if you need the qualification and you want to find it and you believe that you are entitled to that qualification and were entitled at the time that it was granted, then the recourse firstly is an appeal to the tribunal. Secondly, and separately, once if a student has paid a college to obtain a qual, and that qual has been taken from them because the college was either cancelled or didn't do its job correctly, then that student does have a recourse against the college itself, ultimately, because the college itself has given you a statement of attainment or a certificate accrediting you, because it is a national, because the college itself is a registered training organization, is registered to provide that qual. If that qual ends up being useless or being taken from the student, then that interaction, that contractual interaction, can be brought up against the provider. The problem is the vast majority of providers who've had their quals cancelled have disappeared. Yeah, people have disappeared. They get shut down. There's only a few providers that are actually fighting ASQA's cancellation decisions, and I'm acting in some of those cases, but I'm watching those cases very carefully, because it will be a very interesting question if we're successful in some of these appeals that we're running, where ASQA has cancelled qualifications of students, and if it looks like if it looks like we're going to overturn ASQA's cancellation of the college, well, there's going to be a lot of questions asked by the students to ASQA, because if the college comes back to life and ASQA cancelled, 1,000, 2,000, I think 20,000 students have been cancelled so far, it's a very interesting question that will be asked of ASQA.
Makes sense. Perfect. Thank you. And another question is also for both of you, Ben and Peter, both, like whoever can answer. So as there is a difference between governing board and advisory boards, and often have a separate purposes. So for small RTO, is an advisory board sufficient, or should all RTO have the governing board?
Peter, you first.
Everyone should have a governing board. Everyone should have a proper board of directors, but it's not possible because you can't pay people to do it. As a bare minimum, everybody should have a governing board. Everybody should have an advisory board, but ultimately, it's a money question, right? So that's my view. The principle behind it is that you have a group of people not in the day-to-day business providing governance, right? And that's the principle behind this process.
Got it. And as you know, I completely understand, because we're dealing with lots of small RTO and sometimes they don't have that much fund to pay it.
Yeah.
But what I say that you can start small, maybe add one more external person who can be useful for your advisory and also maybe helpful in your doing a monthly spot check. So you are on track. And then if they come once a month for maybe 3 hours or 4 hours, it's not a lot of expenses, but at least you start somewhere. And then as you grow, you can build up from there, because no one is gonna be like 2,000 students straight away, and we have different bodies and stuff. You always start from 10. You always start from 5 students, or always have 50 students. So what I say, if somebody external come and help you, say, okay, we have this problem, we have this, or making some important decision about your continuous improvement, your self-assurance, and also checking some spot check of compliance, it's a good way to start.
Yep.
Got it. Sorry, we have very less time, but I still wanted to cover 2 more questions, because one was, it says, once the fit and proper person declaration has been signed, etc., does the RTO have to pass this document to ESQA?
Well, it depends in what context it has been prepared.
Okay.
Acquisition of a new RTO. If we're buying a new RTO, the new person has to come in. Yes, it becomes part of it. Absolutely. Becomes part of an application.
And one last question that is for Ben, that says, like, they wanted to get an example of misleading marketing. So what is called misleading marketing?
Okay, good question. What is misleading is when you read the standard, we just say you provide truthful, correct, transparent information. And that sometimes also itself is like, how can I define those things? So it starts from that, like if your qualification is superseded and by mistake you're still promoting on your website or any pages, that means it's not a current truthful information. Second thing is, if your RTO is in regional Victoria and on your website you're showing a harbor bridge and promoting that way, so it's still not the correct and truthful information. Where you have a practical workshop, which nobody want to see it, and you're putting the photo, it looks like a world best thing. Other thing is that your information for the course, units, duration, the relevant information that need to be given to the student is not given. So for example, to be part of this course, I need to be physically fit. Somewhere you need to let them know before the course. So all this information, when you combine, when you check, if your misleading information is there, then that can create a problem. And depend on what type of information is incorrect, you get fined accordingly. So if, let's say I have seen that one of the RTO was being issued the fine of $50,000 because they were promoting superseded qualification. So I hope I answered the question.
Yes, I think you have answered the question, and just because we are already running out of time, it's already 12:30.
Before we end up the session, I just wanted to communicate something that we at VET Resources are bringing our monthly webinars from past 4 or 5 months. And thank you so much for all the support and love that our RTO community is showing us. Our next webinar will be happening on 30th of January. And another very special guest is coming. We will send you the emails very soon. I will request everyone, if you can please give a feedback to us. I will be dropping the feedback form. Also, as Christmas is approaching, so I hope your resources are updated and you are well prepared for 2026. In case not, then you can request for free samples. We have the largest catalog of audit ready 2025 standards mapped RTO resources. So you can visit our website and request for free samples as well. Thank you so much, everyone. Also, we will be sending both the slides to you on the email in next couple of hours. The PD certificates and the session recording will be delivered in next 72 hours. Thank you so much, Peter. Thank you so
Thank
much,
you.
Ben,
Thanks, everyone.
for the session, and we are glad.
And
Thanks for attending.
thank you.
I've also attached Peter's email ID, so in case you want you to get in touch with him after this, you surely can.
Perfect, perfect. So once again, it is the end of webinar. Thank you once again to Peter and Ben and Arpit and entire team. Thank you especially Peter for coming and sharing your expertise with all of us. And once again, thanks to all of you as well for joining here. And I hope this session was, of course, it was very informative. Everybody's keep on saying it. And we would love to deliver more webinars just like this, more informative webinars next time. So once again, thank you. I wish all of you a very Merry Christmas and a wonderful holiday season. And we look forward to seeing you all on our next webinar in January 2026.
Yeah. Thank you so much. Thank you, Mahi. Thank you, Arpit. Thank you, team, for the amazing webinar. Peter, it's great to, present the webinar with you. It's always amazing. I got a lot of information. So thank you so much for the adding value to me.
Thanks, Ben. Thanks, everyone.
Thank you all. Have a good
Bye.
time. Bye.